In this week's TWR, we find out that sometimes the people who are meant to enforce the rules against discrimination can't even get it right. This week, we're looking at New Jersey's Administrative Office of Courts and the verdict that just came down against them for $2.5 million related to a disability discrimination claim. But wait, that verdict was just overturned in the appellate division, and we'll talk all about it. I'm Erica Domingo, and this is the Toxic Workplace Report, so let's dive right in. Melissa Migut began working for the AOC in 2002 as a court services officer, where she would check in with individuals on probation at their homes and workplaces. In 2010, she fractured her left leg, which caused her to be out of work for over 16 months and eventually led to a diagnosis of complex regional pain syndrome, or CRPS, which is known to be life-lasting. The AOC created a new data entry position which would allow Migut to return to work and also made other accommodations for her in the workplace due to the fact that she had limited mobility. Despite providing the state's Americans with Disabilities Act coordinator with a doctor's note that said she could not flee from an unsafe situation, the AOC did nothing to make her aware of the emergency procedures that were in place in case of an emergency such as a fire drill or other evacuation. Although her workplace was outfitted with emergency evacuation chairs, which are chairs that look like they're on skis that help someone get down the stairs quickly, Migut was not made aware of this. And in May 2012, when there was a fire drill in her building, she had to go down 5 flights of stairs manually. If you've made it this far in the video, you should probably hit that subscribe button. Migut alleges that walking down 5 flights of stairs exacerbated her CRPS and caused her to suffer from excruciating pain, which she described as an 8 or 9 out of 10, all the way from her ankle up to her scapula. And ultimately, she was unable to return to the workplace because of the exacerbation of her injuries. In 2014, she filed a lawsuit alleging failure to accommodate and disability discrimination under New Jersey's law against discrimination. And in 2018, a jury awarded her $1.7 million for back pay, future pay, as well as pain and suffering and medical expenses incurred. As the prevailing party under New Jersey's law against discrimination, a judge later added attorney's fees and costs to Migut's award. Just last week, the New Jersey Appellate Division overturned the verdict, finding multiple errors at the trial level, including in the instructions given to the jury and comments made by the plaintiff's attorney during her summation, as well as illustrations that were shown to the jury during the summation. The Appellate Division found that the jury verdict sheet, which asked whether the plaintiff had proven by a preponderance of the evidence that her employer knew or should have known about her need for an accommodation, in fact lowered Migut's burden of proof under the law, which requires her to show that the employer was in fact aware of her need for an accommodation. Aside from the improper question on the jury verdict sheet, the Appellate Division also found that the comments made by plaintiff's counsel during her summation improperly played upon the sympathy of the jury. Ultimately, Migut's case will be remanded to the Superior Court for a new trial. Although it remains to be seen what will happen in the new trial, if the facts remain the same in this case and are presented to a jury in the same way, it would appear that the Administrative Office of Courts failed to take into consideration all aspects of accommodations required for Ms. Migut in the performance of her duties and responsibilities. That is, even though they accommodated her day-to-day responsibilities in her position, they didn't consider what was needed in an emergency situation. And we know that to be true because they had emergency policies and procedures in place, but failed to make Migut and her supervisors aware of them so that they could be implemented in her particular workplace. And it's important for the jury to consider the fact that had this been a real emergency, not only Migut's life could have been in jeopardy, but many of the others who were stuck on her behind the staircase as she was trying to get down at whatever pace she could without potentially harming herself, which she ultimately did anyway. And although the facts of this case related to a fire drill, it's important to consider that had this been a real emergency, this may not have only cost Miss Migut her life, but also those of others around her, those who were stuck behind her queuing to go down the stairs and waiting for her to go down at a pace that maybe would keep her safe, although she ultimately wound up re-injuring herself. This case absolutely serves as a cautionary tale to employers throughout the state of New Jersey to consider when making accommodations for individuals with disabilities, not only the day-to-day needs of their position, but also what might be needed in an emergency situation. Thanks for watching TWR number 45. If you haven't liked us yet, what are you waiting for? Hit that button. But you know.
Let's go.
That's all, folks.